Good morning, America. I'm Henrietta Livingston, and you're watching MMHI4 here in Washington, D.C. Today, we will be reviewing the court case of Marbury v. Madison. Marbury v. Madison was the court case that initiated judicial review. This all dates back to when Jefferson won the presidential election of 1800. Jefferson didn't take office until March 4, 1801. Until that day, current President John Adams was in control of the 6th Congress. During this lame duck session, Congress passed the Judiciary Act of 1801. Our reporter Mary Ellen Daughtry will tell us more.
The Act of 1812 reduced the size of the Supreme Court from 6 justices to 5 and eliminated the Justice Circuit's duties. To replace the justice on circuit, the Act created 60 leaderships from 6 judicial circuits just before Adams' term ended. He appointed 16 fellow judges and 42 justices of peace. They were called the Midnight Judges, which included William Marbury.
You're a judge. You're a judge. You'll be a judge too. You're right there. You're going to be a judge. You will be a judge. You'll be a judge. You'll be a judge. That should do it.
The following day, commissions were supposed to be sent out by John Marshall, current Secretary of State. Although the majority of commissions were sent out, it wasn't possible for all of them to be sent before Adams' term expired. Marshall assumed that the new Secretary of State, James Madison, would take care of it. On March 4, 1801, Jefferson was sworn into office and ordered Levi Lincoln, who was acting as secretary until Madison arrived, not to deliver the remaining commissions. Unfortunately, Marbury was one of those who did not receive his commissions. So, because of this, Marbury decided to sue Madison for not delivering his commission. He said it was unconstitutional.
This is for a process known as judicial review. Judicial review is viewed by the U.S. Supreme Court of the moment in effect. The new 7th Congress in Jefferson signed the Judiciary Act of 1802, which amended the judiciary system.
The case started on February 11, 1803. Marbury filed his petition for a writ of mandamus, so his case had to be heard in court.
A writ of mandamus is an order from a court to an inferior government official, ordering the government official to properly fulfill their official duties or correct an abuse of discretion.
Marbury argued that in the Judiciary Act of 1789, Congress granted the Supreme Court original jurisdiction over petitions for writ. That gave the court some questions to ask themselves. Does Article 3 of the Constitution create a floor for original jurisdiction? If Article 3's original jurisdiction is an exhaustive list, but Congress tries to modify it anyway, who is supposed to decide who would win? On February 24, 1803, the court rendered a unanimous 4-0 decision. 26 that Marbury had the right to his commission, but the court did not have the power to force Madison to deliver the commission.
Although the immediate effect of the decision was to deny power to the court, its long-run effect has been to increase the court's power by establishing the rule that it is empathetically the province and duty of the judicial department to say what the law is. Since Marbury v. Madison, the Supreme Court has been the final arbiter of the constitutionality of congressional legislation.
I'm Henrietta Livingston.
I'm Isabel Lawrence. I'm Mary Ellen Daughtry. Irma could not be here today, but we hope you enjoy the show. See you back here next week.
Bye.